nominated to a California seat on the Ninth Circuit. Judge Irma Carrillo Ramirez, nominated to a Texas seat on the Fifth Circuit. Congratulations to the nominees and their families. I also want to thank the California and Texas senators for working with the White House to fill these important vacancies. Before we move to introductions, I'll turn to Ranking Member Graham for opening remarks.
Thank you, Mr. Chairman. Number one, I thought the hearing yesterday was outstanding. And the regulatory approach where you license AI companies with a regulatory agency that can, has the talent and the authority to kind of rein them in seems to be a smart way to go. I have that same approach with Senator Warren with social media. So I hope this committee can continue to work together and come up with a product that maybe our other colleagues will latch on to. So I thought it was a great hearing. You'll get a letter from us pretty soon about the Durham report. Whether you like Trump or not, what happened in the FBI is just mind-boggling. You had a document called the Steele dossier, Mr. Chairman, used to get a warrant against Mr. Page and keep an investigation alive. There was a bunch of Russian disinformation, and it was used time and time again, and the FBI was told numerous times that it's not reliable, and they kept using it anyway. And you mentioned yesterday that there's nothing new in the Durham report. Well, the Durham report, unlike Mr. Horowitz, who did a great job, I thought, said there was never a reason to open the investigation to begin with. So what we have is a situation where the FBI and the Department of Justice used information from agents of a foreign government to get a warrant against American citizens, a citizen, and put a cloud over the Trump presidency and tried to really, in my view, to politically affect the outcome of the 2016 election. They got caught. They wanted it to be true, Mr. Chairman, and when they were told it may not be true, they completely ignored it. It's Republicans today, it could be Democrats tomorrow. So I'm hoping that the committee would bring Mr. Durham in and let him explain to us his report, because I think it is substantially different. And I would just say this. During the Mueller investigation, I, along with Senator Tillis and Senator Coons, introduced legislation that the special counsel could not be removed without cause, because I wanted to make sure that Mr. Mueller could look and find out whether there's any there, even though I was supporting President Trump. Now that it's all over, this is J. Edgar Hoover stuff. And if this committee doesn't bring Mr. Durham in and let him explain to us what he did for all those years, I think we missed an opportunity to learn and take corrective action. So I hope you would entertain that idea. Thank you.
Mr. Chairman, could I just mention something along that same line? I agree with Senator Graham. I think this is a profound assault on some of the most important institutions of our government. The American people simply think that there is a deep state, a conspiracy against political opponents, and it's incredibly dangerous. I couldn't agree more with Senator Graham that this cuts both ways. And while people may like the idea that it was President Trump that was the target of this, these same abuses could easily be turned on other political opponents in the future. So I hope we do the best we can to cut this cancer out of some of our most important institutions. And in that vein, I would hope that we'd get Director Wray to come in and testify about the things he has done to try to correct against these abuses. And the statement I read from the FBI said that they believe that the same sorts of abuse would not have occurred had these measures been in place at the time. I know Director Wray is a little allergic to publicity like any other self-respecting director of the FBI, but I do believe it's really important for us to be able to ask him questions, hard questions, and have him reassure the American people that the appropriate measures have been put in place. And finally, I have not weighed in on the Hunter Biden story before, but what we saw happen with 50 members of the intelligence community, former members of the intelligence community, claim that the investigation of Hunter Biden was in part a product of Russian disinformation, undercuts the credibility of the intelligence community. Again, I'm on the Senate Select Committee on Intelligence. I think our intelligence community plays a vital role in keeping our country safe. But this sort of mixture of politics and policy, particularly with the FBI and now with the intelligence community, is profoundly dangerous. And I'm concerned about it. I hope we have a public airing of this so the American people can see us doing our jobs, because they're going to want to see some accountability and they're going to want to see some course correction. And I think they deserve it. Thank you for a moment.
Thank you, Senator Cornyn. Obviously, we see the Durham report differently, but I do want to make several points here that are important for the record. As Attorney General Garland committed during his confirmation hearings and reiterated at later hearings, there would be no interference with Durham's investigation's independence. That is a striking contrast from efforts by President Trump and Attorney General Barr to politicize ongoing investigations. In other words, Mr. Durham was given resources and time necessary that he thought was necessary to complete his work. Secondly, when it comes to the FBI, 3 times now, since I've been chairman, the director of the FBI has sat in the chair, took the oath, and answered our questions. He'll be in again in the fall for that purpose, and I think that should be a regular occurrence. That is our oversight responsibility. If that's a line of questioning which any member wishes to pursue, that will be their opportunity. So now we go to our nominees, and Senator Padilla, you have an introduction to make.
Yes, good morning. Thank you, Mr. Chairman. Thank you, Ranking Member Graham. It is an honor to once again introduce Judge Ana de Alba to the committee, President Biden's nominee to serve on the Ninth Circuit Court of Appeals. Judge de Alba is joined today once again by her family. I want to welcome them to Washington, to the Capitol, and to this committee. Judge de Alba is a proud daughter of immigrants from Mexico. Judge de Alba was born in Merced, California, and grew up in a family of farm workers. A first-generation high school graduate, she went on to earn both her bachelor's degree and her JD from UC Berkeley. After graduating, she built a successful career in private practice in the Central Valley of California, where she focused on complex commercial litigation while maintaining a robust pro bono practice. She also went on to establish a workers' rights clinic for low-wage workers to learn their rights and seek legal advice. In 2018, Judge de Alba was appointed as a Superior Court judge for Fresno County, where she served until 2022. And I was proud to introduce her before this very committee at the time when President Biden nominated her to serve as U.S. District Court judge for the Eastern District of California, to which she was confirmed. In the time since, she has proven to be more than just a qualified jurist. She's continued to demonstrate an expansive breadth of legal knowledge and an unwavering commitment to public service. Now, this committee, we're asked we ask ourselves this question: who do we want to preside over our nation's laws? Who do we want deciding some of the most difficult and vexing legal questions for our communities? When President Biden entered office, he made it clear that, of course, he'd be selecting judges from some of the most brilliant legal minds this country had to offer. But he also called on us to build a federal judiciary that reflected the diversity of the country that it serves. We were striving for a court system that looks like America. And we appreciate full well why. Because it brings different perspectives to the table, it enriches deliberations, and it builds trust in the judicial system, especially among underrepresented communities. And that's especially important now at a time when public faith in the judiciary continues to be challenged. But it's also particularly important for communities who don't often see themselves represented in positions of power, to know that there's a legal backstop they can trust to protect their rights in a court of appeals. So not only do we know that someone is knowledgeable, as passionate, and as intelligent as Judge de Alba would be the ideal candidate for the Ninth Circuit Court of Appeals, we also know that it absolutely matters to have a daughter of immigrants with the life experience that she brings to serve in this capacity. And we know that it matters to have the perspective of the first Latina to sit on the Eastern District Court, to now serve the largest of all 13 federal appellate courts. She's dedicated, she is fair, and universally respected by her colleagues. And I can think of few candidates as qualified and as prepared for this role as Judge de Alba. I urge my colleagues to advance her nomination. Thank you, Mr. Chair.
Thank you, Senator Padilla. Senator Cornyn to introduce Judge Ramirez.
Thank you, Chairman Durbin and Ranking Member Graham, for allowing me to introduce Judge Irma Carrillo Ramirez, who's been nominated to serve on the Fifth Circuit Court of Appeals. As I mentioned to you privately, Mr. Chairman, Ms. Ramirez is sitting here today and will be confirmed to the Fifth Circuit as a result of a process that Senator Cruz and I have, by which people who apply for these federal judicial positions, both district court and appellate court, agree to go through the Federal Judicial Evaluation Committee, a bipartisan committee of some of the best lawyers in the state of Texas. And Ms. Ramirez came out number one in that process, and consequently, Senator Cruz and I recommended her to the president, and we were delighted that the president accepted our recommendation. He was not obligated to do so, but as I mentioned to you privately, this is an example of how I think the process should work, with collaboration, consultation, and by consensus. But let me just mention Judge Ramirez's story. It's pretty remarkable. She was born in the small town of Brownfield, Texas, just south of Lubbock, and she was raised on a ranch in the even smaller town of, is it Tokyo? It's Tokio. I was born in Texas, lived there my whole life, but I'd never heard of Tokyo, Texas. So it must be a small town. And then she became a self-proclaimed town kid at age 10. In many ways, Judge Ramirez's life and career exemplify the American dream. She's a proud daughter of Mexican immigrants, a fact she takes deep pride in. Matter of fact, her dad came to this country through the Bracero program, and he worked in the cotton fields in West Texas. According to Judge Ramirez, her dad would say, "Study hard so you don't have to work in the fields like I do." I think a lot of immigrant parents have felt the same way and conveyed the same message to their children. Clearly, Judge Ramirez took her father's advice. In 1986, she received her undergraduate degree from West Texas State University, which is now called West Texas A&M. She went on to earn her Juris Doctor from Southern Methodist University Dedman School of Law in 1991. After she completed her law degree, Judge Ramirez began working at the prestigious Dallas firm of Locke, Purnell, Rain, and Harrell. She went on to serve as an assistant U.S. attorney in the Northern District of Texas, where she established herself as a top-level prosecutor, working on both civil and criminal cases. Having carved out a reputation in the Northern District as a great advocate, Judge Ramirez was selected by a highly competitive merit selection panel to be a U.S. magistrate judge for the Northern District of Texas, where she served since 2002. And she's earned the respect of virtually every person with whom she has crossed paths, including myself and Senator Cruz. As a magistrate judge, Judge Ramirez has been recognized by her peers in the Northern District Bar for her outstanding contributions to the law. She's received numerous awards, including the Dallas Hispanic Bar Association's La Luz Achievement Award and the SMU Dedman School's Law Distinguished Alumni Award. She's been assigned approximately 2,450 civil cases for full case management and has been the presiding judge for more than 440 consent cases. Magistrates can't try those cases without the consent of the parties, which to me is a great vote of confidence of the bar that they would allow the magistrate judge to do that as opposed to kicking it upstairs to the district court. Judge Ramirez has also worked with the U.S. Attorney, the Public Defender's Office, and the Probation Office to improve reentry efforts at the federal level for first-time low-level offenders, something we've worked on here in the Senate Judiciary Committee, and to try to help people turn their lives around and lead healthy and productive lives. Judge Ramirez's work has served as a model around the country. If confirmed, I'm confident she'll bring the same passion, commitment, and fidelity to the law that we've seen throughout her career. You can tell that Texas is very proud of Judge Ramirez, not only by the Texans who are seated in the audience cheering her on, but I'm eager for our Senate colleagues to hear more about her career and qualifications. And I hope that at the end of today's hearing that all of our colleagues will agree that Judge Ramirez is exceptionally qualified for a seat on the federal bench. Thank you, Mr. Chairman.
Thank you, Senator Cornyn. Let me personally thank you and Senator Cruz for your efforts to work with the White House to find this nominee. Many of us, Senator Graham and myself, believe in what's known as the blue slip process, which basically says that senators will have some say in terms of the judges that are chosen in their states. There are critics of that process, as you know. I want to overcome that criticism with results where we can have bipartisanship in the selection of judicial nominees, and this is a good example. So thank you very much for being part of that. Let me ask the two nominees to come forward to the table, please. Stay standing for just one moment. Raise your right hand. Do you swear or affirm the testimony you're about to give before the committee is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please take your seats. And we give you each 5 minutes to say hello, introduce family and friends, and any other comments you think appropriate. Judge D'Alba.
Thank you, Chair Durbin, Ranking Member Graham, and all of the members of the Senate Judiciary Committee for holding today's hearing. I would also like to thank my home state senators Feinstein and Padilla for their unyielding support and encouragement, and President Biden for this nomination. I last sat before you fielding questions regarding my desire to serve in one of the busiest districts in this nation. Since being confirmed, I have had the great privilege of serving the people of California's Eastern District, a district that serves almost 8 million residents, encompasses 6 large urban areas, and extends over 87,000 square miles. I inherited a docket which at last count had 1,156 cases. While on the Eastern District, I have issued over 1,000 orders. I have done this with great pride and humility, understanding that my role on the bench is that of service. It is with that same belief that I come before you now as a nominee seeking a position on the Ninth Circuit Court of Appeals. Here with me are my best friend, Francisco, and our daughter. We are so very fortunate to get to be parents to this amazingly kind and intelligent person. I only hope to be able to make her as proud today as she makes us feel daily. Cheering me on from California is the rest of my family. In late February, after having survived a bout of liver cancer, my oldest brother, Fernando, received a liver transplant. Unfortunately, the transplant resulted in more complications than expected, and our family is home supporting Fernando, his wife, and his children as he navigates this new world. Despite this, they are watching and supporting me from afar. Thank you, and I love you. I would also like to thank my courtroom deputy, Mamie Hernandez, and my law clerks, who have been my tireless support system by helping me stay atop of my caseload during my biweekly travel to and from San Francisco for Fernando's appointments. And finally, I would like to thank my friends and former colleagues who have sent their well wishes throughout this process. I feel your support here with me today. Thank you. Senators, I look forward to answering your questions.
Thank you, Judge. And now, Judge Carrillo Ramirez.
Thank you, Chair Durbin, Ranking Member Grassley, the members of the committee, for the honor of witnessing firsthand the process by which the Senate performs its constitutional duty to advise and, if appropriate, consent to the President of the United States. Thank you to my home state senators for their support, Senators Cornyn and Senators Cruz, and thank you, Senator Cornyn, for those exceedingly kind remarks. I'd also like to thank the President of the United States for the honor of this nomination. With me today, I have my husband of 37 years, Adam. Although we've lost our parents, we still have a very large, extended, and rowdy family, and they are watching. We thank them for their love and support. We are also very fortunate to have many dear friends, and some are here with me today. Mildred Benson, Vicki Blanton, Hilda Galvan, Denise Garcia, Teresa Guerras Nelson, Stacy Jernigan, Nancy Koenig, Robbie Partida Kipnis, and Sara Saldana. Time will not permit me to thank all of the people who have been part of this journey, but I would like to recognize and thank in particular two groups of people. The lawyers with whom I served at Locke Purnell Rain Harrell and the United States Attorney's Office, and the judges of the Northern District of Texas with whom I've served for the past 21 years. They have modeled excellence, adherence to the highest ethical standards, and a commitment to the rule of law. I have learned much from them, and I thank them for that. I'd also like to thank all of the staff members who have supported us in our work, the court family, and in particular, my courtroom deputies, my staff attorneys, and my law clerks. One is here today. Finally, I would like to thank the Dallas legal community, which funded the scholarship, which allowed me to attend law school. I'd also like to thank the Texas community for its outpouring of support, and those who paved the way before me so that I could be here today. I look forward to your questions.
Thank you very much, Judge Ramirez. Each of us will ask 5 minutes worth of questions, and I'll start. I noticed that your work with the reentry program is part of your professional responsibility. We all know that people once sentenced are separated from family and friends and denied many rights, and we hope that they will view this experience in a positive way and change their lives afterwards. Sometimes we succeed and sometimes we fail. What lessons have you taken from your experience in terms of recidivism and how to avoid it?
The biggest lesson has been some of the obstacles that people face when coming out of prison. Housing, employment, support, substance abuse, mental health. There are many struggles that I was not aware of. And the reentry program has provided a means to help people address these issues so that they can live law-abiding, healthy lives. The program has taught me so much, Senator, more than anything, about the power of redemption. People truly do want to do better and live healthy lives. Sometimes they just don't know how.
I think that's a very valid point. Also, I'll note for the record that both you and the nominee from California have been judge qualified by the American Bar Association, so there's no question about your experience in terms of your life and also your integrity. So I thank you for being here. Judge D'Alba, there was a point in your life when you were in private practice and established a workers' rights clinic. Why did you do that, and what was the result?
Senator, when I was a young child, I worked in the fields with my mother. And my parents were immigrants from Mexico. They had no education. We were field workers just to make ends meet. All of us had to work in the fields, my brothers included. One summer, my mother didn't get paid. She was promised to be paid next week. And it kept happening. We'll pay you next week. We'll pay you next week. At the end of the summer, the rancher filed for bankruptcy, and so there was no pay. That summer, we went without school clothes. So for that school year, we didn't have school clothes. And it stuck with me for various reasons. One, I vividly recall my mother crying in the bathroom. Like, I heard her. She hid it from us, but I could hear her crying. And it just also so happened to coincide with, I have 3 older brothers, with the youngest of the 3 older ones having a growth spurt. So my poor brother had to go through the 8th grade with high waters because he outgrew his pants. And as much as my mom tried to undo the hem to get them to be long enough, it wasn't enough. He grew about 3 inches that summer. So it was that kind of experience that I had that led me to figure out a way, just if we could give people information. The clinic didn't take cases, the clinic didn't represent individuals, it just gave them information to know what their legal rights were. So it was a lived experience that I had that helped me put this together.
Thank you very much. I'm going to turn now to Senator Graham.
Thank you. Congratulations to both of you and your families. Judge Alba, are you familiar with do you remember the case United States versus Hernandez-Fields? It's a child pornography case.
Senator, yes, I vaguely remember that case.
Okay. According to my records here, the defendant was convicted of receiving and distributing child pornography, including images of children being sexually abused, images of young minors, as young as toddlers, having objects inserted into their bodies in a sadistic manner. The sentencing guidelines range from 78 to 97 months. The government asked for a 97-month sentence. The parole officer originally recommended 111 months, but then revised it down to 66 months. And apparently the defendant told the parole officer they had no sexual interest in children. That seems to defy the facts of the case. You imposed a sentence of 66 months. And I would encourage the members of the committee to look at the record if they so choose. Why did you do that?
Senator, as a federal district judge, whenever I impose a sentence, I am required to do an individualized assessment. I need to look at the factors at 18 U.S. Code Section 3553A, as well as looking at the probation pre-sentence report, any objections thereto, the request from the defense and from the government, any victim impact statements, and any letters in support, or in that situation as well, any...
In that regard, do you remember the government telling the court the defendant's conduct reveals that he is an extreme risk to minors? Do you remember that?
I don't recall the specifics, Senator, but I do know that I am required to do an individualized assessment, and I did look at everything that was provided to me in that case, as I'm required to by both Ninth Circuit precedent, Supreme Court precedent, and the factors at 18 U.S. Code 3553A.
Are you aware of the fact that when he told the parole officer he has no sexual interest in children, that he had told psychologists and law enforcement the opposite? Do you believe this defendant had no sexual interest in children?
Do I independently believe that?
I mean, as a judge, did you buy what he was saying?
No, Senator.
Okay. All right. Do you remember a case involving taking a GPS monitoring device off a defendant who was convicted of helping his brother evade capture? His brother had killed a police officer, Corporal Singe, and he had been wearing this monitoring device for 4 years. You decided to replace or take the monitoring device off of this defendant without a hearing. Do you recall that?
I do not recall that case, Senator.
Okay. Thank you very much.
Senator Padilla.
Thank you, Mr. Chair. Let me begin with a question for Judge de Alba. Judge, you served for several years on the bench, both at the state and now at the federal level. But before that, you worked for about 10 years as a civil litigator, where you gained tremendous experience in the courtroom, everything from complex work for paid clients as well as extensive pro bono work on behalf of indigent clients. How will your work as an appellate judge be informed by your experience as an advocate in the courtroom to date?
Thank you, Senator Padilla. Currently, as a sitting federal district judge, part of my job is quasi-review in nature. I do review the findings and recommendations that are provided to me by the magistrates. I also review any bankruptcy decisions that are appealed. So in that regard, I am already looking at decisions by other judges, making sure that we apply the correct standard of review, and doing things of that nature. As a young attorney and as an attorney throughout my career, I have always been cognizant of the importance of, frankly, being credible with the court and making sure that what I write and what I say, I can tie back to the law, tie back to the facts. And I think, especially as an appellate judge, that is extremely important because we are limited to the record that is provided to us, so that when we write our orders or our decisions, they can be tied back to that record. In addition, currently on the federal bench as well as on the state court bench, I had a lot of exposure to First Amendment, Second Amendment, Fourth, Fifth, Sixth, Seventh, and Eighth Amendment issues, as well as a wide array of issues in the civil arena as well, which I know will help me extensively on the Ninth Circuit. Thank you, Senator.
Thank you. The next question I'll ask it of both of our nominees today is one that I ask every chance I get, and that is the topic of diversity, not just the importance and the value of diversity broadly, not just the importance and value of diversity in the judiciary, and not just on the importance and value of diversity for those who seek to serve on the bench, but throughout the courtroom, and in particularly law clerks. As both of you probably can appreciate, law clerks play an important role in chambers. And a good law clerk experience is oftentimes the foundation or a launching pad, frankly, to a successful career, whether it's in public service or in private practice. But too often women and minority law students are overlooked when it comes to quality law clerk opportunities or experiences. Let me begin with Judge Ramirez. First of all, do you agree with what I've just expressed? And if so, what steps would you proactively take to advance diversity in your chambers should you be confirmed?
Senator, over the past 21 years, I've been fortunate to work with many talented law clerks. They have come from very diverse backgrounds, different parts of the country, different law schools, different socioeconomic backgrounds, different races, different national origins, different faiths and no faiths, different sexes, different sexual orientations, different ages, and different ranges of experience. They've all had some traits in common. They've all been very bright, talented lawyers. They've been very hard workers. They have been good writers, and they have been dedicated to the rule of law and to helping me do my job as best as I can. I have learned something from each and every one of them, and I thank them for their service.
Thank you. And we would expect that to continue, should you be confirmed. Judge D'Alba, same question.
Thank you, Senator. Similarly, granted, I've only had one set of law clerks, but it has been a tremendous experience. We have had a very open door policy in my chambers. That was from day one. I wanted them to feel comfortable to come to me and ask questions, not only about the cases that we're working on, but about their future, their careers, what it is that they wanted to do. And I have found that doing that really does make a difference. And they have been telling, for example, their friends or their law school, you know, Judge D'Alba's great. You should get people to come and apply to work with her. They would have, a wonderful experience, which I think makes people who otherwise may not think that a judicial clerkship is for them actually come and apply.
Thank you. And Mr. Chair, just in closing, we'll not ask to enter into the record. I believe they're already part of the record, but would like to acknowledge letters of support for Judge D'Alba's nomination from the Fresno County Chief Probation Officer, an Assistant District Attorney, Deputy District Attorneys, retired Magistrate and Superior Court judges, sitting Superior Court judges, and many others. Thank you, Mr. Chair.
Without objection. Senator Cornyn?
Thank you, Mr. Chairman. To begin with, I'd like to ask unanimous consent to offer this letter of endorsement by the Hispanic National Bar Association into the record
Without objection.
Judge Ramirez's nomination. So, Judge, I feel like I know you pretty well by now, at least professionally, but I'm intrigued by your family's story. Your dad was part of the Bracero program. As Ms. Saldana will know, as a former director of ICE and former U.S. attorney, we've struggled with immigration issues for the whole time I've been in the Senate and even before that. But tell me a little bit, I'm not going to ask for your policy advice or recommendations, but I'm just wondering if you can talk a little bit about your family's experience with that program.
My father came to this country in the late 50s under the Bracero program from Mexico to work in the cotton fields of West Texas. That's where he met my mother. Her family was from South Texas and had settled in that area and also worked those cotton fields. As you noted, Senator, I remember as a child very vividly him telling me, "Estudia, mija, study, so that you don't have to work in the fields like I do." And my summers spent hoeing cotton in those fields only served to reinforce his message. Becoming a judge or even a lawyer was so far beyond his hope of an inside job for me that we couldn't begin to imagine it, much less dream it.
And by inside job, you mean a job where there was air conditioning?
Absolutely.
I know that's motivated many of us to pursue our education, is the opportunity to work indoors in air conditioning in the hot Texas summers. By the way, how big is Tokyo, Texas? What's the population?
I'm not sure it's there anymore beyond the sign. The Anderson's Grocery long ago fell down, and so did the...
How many people were there when you lived there?
Maybe about a dozen.
Okay. Well, that maybe explains why I had not previously heard of it. Thank you very much. Congratulations.
Thank you, Senator Cornyn. Senator Hirono?
Apparently just in time. So I asked the following two initial questions of all nominees on any of the committees on which I sit. So I will ask the two of you the initial questions, and I'll start with response from you. So since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
I have not, Senator.
No, Senator.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
I have not, Senator.
No, Senator.
Thank you. For Judge D'Alba, pro bono work, in your time in private practice, you averaged 250 to 300 hours of pro bono service per year. That is significant. And that this service included helping create a monthly workers' rights clinic to help employees understand their rights, representing individuals in front of administrative bodies, and counseling nonprofits on relevant parts of the law. Why was or is pro bono work so important to you being a lawyer?
Thank you, Senator. When I was an attorney, actually I became an attorney with this idea that if we could provide just a little bit of information to folks, just if they knew their legal rights, that could give them a little bit of a leg up. It could just put them on even footing. It could get them to be able to help themselves a little bit better. A little bit earlier, I told a story about my mother not getting paid after working an entire summer and the rancher filing for bankruptcy. Had she known that she could have become maybe a creditor on that, you know, on his bankruptcy, maybe she could have gotten some money. But for me, it's extremely important to be able to just give a little bit of information back. And as an attorney, I always, felt that bar card that I had was almost like a superpower, right? It took me 5, 10, 15 minutes to explain to someone their legal rights, but it could literally change their life. And so to me, it felt like it was the least I could do.
So you created a workers' rights clinic. Where was it, at your law school or at a law school, or where?
So no, in Fresno, there wasn't a clinic created. So what I did was I created a clinic with Legal Aid at Work. It's a nonprofit organization in San Francisco. They had numerous clinics throughout the state with the Consulate of Mexico in Fresno, who had been my client, my then law firm, and CCLS, Central California Legal Services. And all of us got together one Thursday a month to provide free legal services, just information. I then would take cases pro bono if it was just a quick, Berman hearing or hearing before the labor commissioner.
So do you think that all of the pro bono work that you did will really inform your approach to being a judge on the Ninth Circuit? And if so, how?
It certainly does. It has informed everything I've done, in fact. It has informed me as an attorney, it informed me as a Superior Court judge, and certainly it has informed me as a federal judge. And I think that will carry through at the appellate level as well. There are a lot of individuals who file their appeals pro se, especially individuals who are incarcerated. And I think having that in the back of my mind, remembering that not everybody can afford an attorney, not everybody can necessarily have the help, will definitely help me be more understanding and patient, frankly, when I'm reviewing all those documents.
Can I ask you both very briefly, because I am running out of time? In my view, diversity on the bench is really important. Can you talk a little bit about what your thoughts are about diversity on the bench, both of you, very briefly?
Sure, I agree with you. I think diversity is important because it has a role modeling function to it. I said this the last time I was here, if you can see it, you can be it. And, as a person who didn't have a bed to sleep in until I was 15, it's really nice to be able to say, look, now this is the second time I sit before the Senate Judiciary Committee hoping to be confirmed.
Ms. Ramirez?
A judiciary that is representative of the community it serves instills confidence in our system of justice. And it reaffirms the American dream that the daughter of a bracero can be nominated to sit on a United States Court of Appeals. Before I was a judge, a little girl asked me if girls could be judges too. And the hundreds of students that I've spoken to since then only confirms that what I show them speaks far more loudly than what I say to them.
Thank you. Thank you, Mr. Chairman.
Thanks, Senator Rono. Senator Lee?
Thank you, Mr. Chairman. Thanks to both of you for being here. Judge D'Alba, in the case of United States versus Tanner Joel Hernandez Fields, you sentenced a defendant who had pled guilty to child pornography charges. Now, the initial pre-sentence report prepared by the Office of U.S. Adult Probation and Parole recommended a sentence of 111 months. And a later report recommended a downward departure from that, a sentence of 66 months. The guidelines range was 78 to 97 months, and hence the downward departure. Now, the prosecution noted, disagreeing with the second pre-sentence report, that the defendant's conduct revealed that he was an extreme risk to minors, given that he had demonstrated a sexual interest in minors even after having been arrested by law enforcement and having been subjected to the criminal justice system as a result. And they went on to explain how he had repeatedly acted on his interest in minors. They pointed out, moreover, that they disagreed with the second pre-sentence report and the recommendation for the downward departure based on the fact that there was a discrepancy and a discrepancy between what the defendant had said to some people and what he had said to others. Here's what the government pointed out. Quote, the discrepancy between what the defendant apparently told the probation officer who prepared the pre-sentence report, that is, that he does not have a sexual interest in children, and what the defendant previously stated to law enforcement and the psychologist who prepared a report of his defense, to whom he said that he does have a sexual interest in children and was in fact comforted by viewing child pornography. Now, can you explain why you made the decision to depart from the guidelines, notwithstanding this discrepancy between what he had admitted to the psychologist and what he claimed was the case to the probation officer preparing the report?
Senator Lee, as I mentioned earlier, I am required to look at many factors when I sentence a defendant. Anytime I impose a sentence, I'm required to look at factors under 18 U.S. Code Section 3553A. The Ninth Circuit, as well as Supreme Court precedent, also require that I look at, as you stated, the pre-sentence report. I also need to look at any requests from defense.
Sure, yeah, I understand that.
The
I'm just
victim.
asking about this case. So.
And I know, Senator, that you mentioned that there was the discrepancy there because he said before, I'm not interested in kids, and I am interested in kids. I don't recall that that was the reason for the request for departure from probation. So I don't think probation believed him, and I don't think that that's the reason why they requested the downward departure.
He sexually assaulted a child, and you gave the downward departure. Notwithstanding the fact that he admitted to this ongoing, he admitted to and engaged in conduct consistent with his ongoing sexual attraction to minors. Do you recall your basis for the departure?
No, Senator, what I was saying is I got the impression that you were explaining to me that the reason that probation departed was because he said he wasn't attracted to minors, and that was not my understanding of why they requested
what was
for the
your
departure.
reason? What was your reason?
So, Senator, I look at everything. I have to look at everything that's presented to me, and it's after looking at everything that I make that determination. I have to do an individualized assessment of every thing that comes before me. And I can tell you as an example, 2 or 3 weeks ago, I sentenced a different defendant who was sexually trafficking minors to the full amount, which was, I think, 232 months at the time. So it's an individualized assessment. There isn't one specific thing that, changes my mind one way or the other. I have to do what the law requires me to do, frankly, what the legislature requires me to do, what the Supreme Court requires me to do, and what the Ninth Circuit requires me to do, and that is to give an individualized assessment to each defendant in each case.
No, I understand that, but in order to downward depart, you've got to find something about the case that takes the case outside the heartland. Here you have a child sex predator who sexually assaulted a child. So that's what I want to know, is what was it about this specific case that took this case outside the heartland, warranting a downward departure?
I don't recall specifically what it was. I do recall that it was, if I recall correctly, I believe I sentenced him in line with what probation requested as to the second report. But I don't recall what the downward departure request, what the basis was.
Okay. I see my time's expired. I may ask you about that and a couple of other things in written follow-up. Thank you, Mr. Chairman.
Thank you, Senator Lee. I'm going to ask unanimous consent to enter in the record summaries of 4 cases here which speak to this question of the sentencing experience of Judge D'Alba. United States versus Zuniga, a case this year involving coercion to engage in sexual activity with a minor. Judge D'Alba sentenced the defendant to prison for 36 months, followed by 120 months of supervised release, the exact sentence requested by the government. In United States versus Nickel, the defendant was found to have violated terms of his release by possessing without authorization sexually explicit material of a minor. You imposed a 24-month sentence, followed by 231 months of supervised release as recommended by the government. At this point, Senator Cotton, I believe, is next.
Today we're holding another confirmation hearing. We do this a lot, so it can seem routine, but it's not. I want to tell a story about why it's so important that this committee thoroughly vet all nominees. Yesterday afternoon, we received the welcome news that Rachel Rollins, a radical pro-criminal Soros prosecutor, is resigning in disgrace from her perch as the U.S. Attorney in Massachusetts. Over 18 months ago, my colleagues and I warned that Rollins was unfit to serve as a U.S. Attorney. My Democrat colleagues refused to listen, and every single one voted to confirm her nomination on a party line vote. It was the first time in 28 years that we'd held a roll call vote on a U.S. Attorney nomination. The last time was in 1993 when Janet Napolitano earned a roll call vote for her role in smearing Justice Clarence Thomas, which this committee continues to do to this day, this afternoon even. This vote was a rare case, of course, but Rollins was uniquely unqualified. Her opposition was neither partisan nor reactionary. During the same session on this committee, we deadlocked on her nomination. We also voice voted another 8 U.S. Attorney nominees. Rollins' record, however, was different. Professionally, she openly said her goal as a prosecutor was to dismantle the criminal justice system from the inside. She also described the U.S. criminal justice system as, and this is a quote, a cruel and oppressive force of injustice. As a district attorney, she refused to allow her prosecutors to enforce laws against fentanyl trafficking, breaking and entering, resisting arrest, or malicious destruction of property, among other crimes. But her problems were not limited to her abysmal professional record. Rollins' temperament and judgment was also in question. We learned of a curious case of road rage where Rollins forced another vehicle out of the merge lane, threatened the driver, and turned on sirens that, for some reason, she had in her car before she sped off through a red light. When a local news crew asked her about the incident, Rollins threatened the news crew as well, saying, and this is a quote, "I'll call the police on you and make an allegation, and we'll see how that works with you." Rollins' record was clear at the time. She thought the rules didn't apply to her, that she could use law enforcement as a weapon against anyone who questioned her, and any criticism of her record was racist. My colleagues ignored those red flags, and every Democrat voted in lockstep for her. Before long, Rollins used her newly confirmed position as federal prosecutor for her own personal and political benefit, violating numerous laws. She even improperly accepted and failed to disclose gifts of lavish travel from groups where she had no personal connection. I referred Rollins for an investigation by the Department of Justice Inspector General, and just minutes ago, the Inspector General released a damning report. Over 150 pages of findings of wrongdoing. Just a short sampling. Rollins used the office to launch a bogus investigation and then leaked it to the press to influence a district attorney election. Rollins used the office to get free tickets to the Boston Celtics. Rollins repeatedly lied to the Inspector General during the investigation. It's no surprise that someone who refused to enforce the law also refused to abide by it. Rollins is now running out of office one step ahead of the sheriff. Good riddance. To the nominees here today, you're nominated to lifetime appointments, so the stakes are even higher. I'll submit questions to both of you in writing, and I would respectfully request that you submit your answers promptly. To other Biden officials, including at the highest levels of the Department of Justice, who continue to similarly abuse their positions, accountability will be coming for you too. I'll also note the Inspector General referred Rollins to the Department of Justice for a criminal investigation, and yet again, the politicized Biden Department of Justice refused to investigate its own political cronies, declining prosecution of a woman who repeatedly lied to the Inspector General. And in the meantime, including this past week, my Democratic colleagues continue to force radical nominees through on party line votes. I hope that this humiliating episode of support for the disgraced Rachel Rollins will give my Democratic colleagues a change of heart, and they'll begin taking their role in vetting Joe Biden's nominees a little more seriously.
Thank you, Senator Cotton. Senator Kennedy.
Thank you, Mr. Chairman. Judge D'Alba, Judge Ramirez, congratulations to you both. Judge D'Alba, do you think, I want to wax a little philosophical here, do you think a person's race should be used to harm that person?
No, Senator.
How about you, Judge Ramirez?
No, Senator.
Okay. Judge D'Alba, do you think that a person's race should be used to help that person?
No, Senator.
Okay. How about you, Judge?
No, Senator.
Okay. Judge D'Alba, why is that?
Well, as a legal standard, Senator, we try to look at people just based on either, if we're in a criminal position, we're looking at them for what they've done. In a civil matter, it usually doesn't come into account. So, and also it's something they don't necessarily control, so it seems unfair.
Okay. Judge Ramirez?
The Constitution provides for equal protection for all.
Okay. Judge D'Alba, this has been in the news a lot lately, and you'll probably see it if you're confirmed to the Court of Appeal. Tell me about the Dormant Commerce Clause.
Senator, I'm somewhat familiar with the Commerce Clause, which is found in Article 1 of the Constitution.
Well, there was a big Supreme Court case that just came out of your state.
And I apologize, Senator. In my 11 years of practice and my 5 years on the bench, I have not dealt with the Dormant Commerce Clause, but if I am so fortunate enough to be confirmed and have to deal with it in the future, I would certainly research it and, be prepared.
All right, then just tell me about the Commerce Clause in general.
So my understanding about the Commerce Clause, like I stated, Senator, is that it is under the Article 1 of the Constitution, and it allows the legislature to create laws that allow for movement and things related to commerce in the United States. So anything crossing state lines, things like that.
So it allows Congress to regulate commerce.
Yes.
Between whom?
Between states, for example?
Mm-hmm.
Yes.
Anybody else?
It's not coming to mind right now, Senator.
Okay. All right. You're familiar, Judge, I'm sure, with the Fourth Amendment and the warrant requirement. What's, just for the record, what's the warrant requirement?
The warrant requirement requires, so Fourth Amendment says that we are not subject to unreasonable searches and seizures. So in order for someone to, for example, enter our home, there needs to be a warrant. And in order to get a warrant, an officer has to, under oath, state that there is probable cause to believe that either a crime has been committed or there is a crime afoot, and that they have to describe with particularity the place to be searched.
And that's based on the Supreme Court's interpretation of the U.S. Constitution, correct?
Yes.
Okay. Let's suppose that Florida passed a law and said, we don't agree with the Supreme Court's interpretation of the Constitution and the Fourth Amendment and the warrant requirement. We're really concerned about the power of the state. And we're going to ignore the warrant requirement that no police officer has the right to come in your home, probable cause or otherwise, unless you agree to it. Would that be legal?
Well, Senator, I'd have to, it's somewhat of a hypothetical question, but I would
It's a very real question. Happened before. Would that be legal?
I would have to look at it a little bit more carefully, but, on first blush, my concern would be that under the Article 6, the U.S. Constitution is the supreme law of the land.
Yeah.
So we have to follow it.
What if Florida said under the state constitution, we're doing this? Does the U.S. Constitution always, or the Supreme Court's interpretation of the U.S. Constitution always prime a state constitution?
I have not dealt with that issue
Well,
in
there's a big case out of your state that deals with this issue.
it.
You familiar with the Prune Yard case?
The Prune Yard case I am familiar with.
Tell me the holding of that.
The holding of that was, it had to do with individuals who wanted to,
Yeah, but just tell me the holding. I remember the facts. Tell me the holding.
the holding was that the takings clause didn't apply to individuals outside of a shopping center who wanted to protest or
Yeah,
because.
but the point I'm trying to make is that the U.S. Supreme Court in that case said that the California Constitution primes the federal Constitution, didn't it? Isn't that what it said?
Yes, Senator.
So you want to go back to your answer about the Florida hypothetical I gave you?
As I stated, Senator, if I had a little more time to look at it and really think about it, I would
Okay.
be able to come up with something.
Thank you, Judge.
Senator Blackburn?
Thank you, Mr. Chairman. Congratulations to each of you on your nominations. My questions today, Judge Alba, I'm going to come to you. I want to talk with you a little bit about the Virgin Mendoza case. And you released an illegal immigrant from GPS location monitoring after he was convicted for helping his brother. The brother had murdered a police officer. And Mendoza helped his brother evade law enforcement. So to justify your decision, you relied on the words of this defendant that he said he would never flee and he would never leave his family because he wanted to avoid a 21-month sentence. But he had helped his brother to evade law enforcement. And the fact that he repeatedly lied during this investigation should have been something that was going to make him ineligible for being released from location monitoring. So we are seeing a terrible rise in violent crime in this country, especially in larger cities. And I just cannot imagine how you could have justified releasing this person from location monitoring after he had helped a cop killer evade arrest. Can you explain that to me?
Senator, I'm not 100% sure if I remember this case. As I mentioned earlier, I have 1,156 on my docket, but if I do remember correctly, is this the one where ICE also had location monitoring on him?
I know that he had location monitoring on him and that you allowed it to be removed, and you wrote a lengthy order on this, granting that removal. You never mentioned the fact that the defendant's brother had murdered a police officer, which is ultimately why the defendant was convicted in the first place. So it appears that that was not a fact that was important to you in your process. And I think we just have to look at what is happening with crime in our cities, and your decision that was here to remove that and to allow this guy to go forward. I mean, we have such a problem with people that are trying to evade law enforcement. Let me move on. I know that Senator Lee asked you about the Hernandez-Fields case, and I had looked at this case. I do not see how you could justify your decision there. But the fact that this is someone who had demonstrated for many years his sexual interest in minors, by obtaining and viewing images of children being sexually abused. This was a known fact to you. So did all of this not give you any pause as to what was happening? When you looked at these sentencing guidelines and when you looked at the filing on this person, did his interest in minors not give you any pause? Because human trafficking, sex trafficking, what is happening to women and children that are coming across that border, what we are seeing happen to these individuals, how could you possibly support release?
Senator, as I said, I have to make an individualized assessment based on everything that is presented to me. It wasn't supporting release. I did give him 66 months plus a lengthy sentence following supervised release following his 66 months in custody. I had been a juvenile court judge prior to coming to the federal bench, so I fundamentally understand how this impacts youth and how this impacts the public.
Your approach on the sentencing guidelines is what has concerned me as I reviewed those two cases, one dealing with law enforcement, one dealing with children. I've got one other question for you. You gave an interview with Super Lawyers magazine some years ago, and you described yourself as a lefty liberal from Berkeley. And my concern would be how people can look at you and say, we trust that this is someone who's going to be fair and impartial, if that is your description of yourself, your judicial philosophy. So do you still consider yourself to be a lefty liberal from Berkeley?
Senator, respectfully, that was a quote in jest, because that's what my former law firm partners referred to me as, because I attended Berkeley as both an undergraduate and a law student. But as to the core part of your question, it has more to do with the fact that the type of judge that I will be is a type of judge that I have been. I have been fair. I do individualized assessments. I do look at every case as I'm required to look at it on an individualized basis, and I would continue to do that. I do apply the law to the facts, and I apply and adhere to all binding precedent.
Thank you, Mr. Chairman.
Thank you, Senator Blackburn. Since this case has been brought up 2 or 3 times, I made a point of reading a summary of it, United States versus Virgin Mendoza, and as I understand it, the defendant in the case was requesting the removal of one of his 2 location monitoring devices that he was wearing. Over the course of 4 years, the defendant had been subject to wearing 2 ankle monitors, one from the federal agency ICE, the other from Pretrial Services Office. You granted the defendant's motions and granted the removal of one device. And you noted in your order that the defendant had been residing in California for 22 years, had 3 U.S. citizen children and a spouse, was not in removal proceedings, had an active visa application pending, had continually complied with all conditions of release over a prolonged period of time, and had never missed a court date. I think that sheds a little more light on what the decision was. When he left, he was wearing the more restrictive device that limited his territory that he could legally occupy. So you took one of the ankle devices away. That seems to be, does that refresh your memory of the case?
It does, Senator Durbin, so thank you for that. Yes, he had 2 ankle monitors. The request was to have one removed, and if I remember correctly, I think probation was actually in support of that, that one of them be removed. So,
Thank you.
Thank you for clarifying.
Senator Padilla, you've heard.
Thank you, Mr. Chairman. Welcome to both of you. Judge Ramirez, I want to congratulate you on your nomination. You were last before this committee in 2016, at that time in contemplation of an appointment for the U.S. District Court in Dallas. So you are an exemplar of the old adage, patience is a virtue. And I will also say that your nomination is an example of what we can accomplish when the process operates and when the White House works cooperatively with the senators from a home state. As you are well familiar, as are other members of this committee, so I thank your service, and I think given the debates and rumblings in this committee, I think this is an illustration of how the process can work and work well. When the White House decides to disregard the views of the home state senators and approach it in an antagonistic manner, that can be an example of how the process does not work well. I want to turn to our other nominee today, Judge D'Alba. And I want to start with a case that has been asked about quite a bit, but I want to go back and revisit it. U.S. versus Conrado Virgen Mendoza. The defendant was an illegal alien. He was subject to deportation. He assisted his brother to evade law enforcement. Officer during a routine traffic stop. So this was not a minor criminal matter. The defendant's role included concealing the truck that the killer was driving when he killed the officer, helping dispose of the loaded firearm the killer used to murder the police officer, driving the killer through Stanislaus, San Joaquin, and Merced counties to find a place to conceal him, and lying to and delaying law enforcement efforts to locate the killer as he moved closer to Mexico. By the defendant's own admission, he was a Mexican citizen with close family members in Mexico. He was illegally in the United States, and he had previously been removed from the border. He had every incentive not to stick around and get convicted. And yet, somewhat inexplicably, you granted the defendant's motion to remove the GPS location monitoring device assigned by a prior judge that the defendant had previously worn for about 4 years. Before granting that motion, did you hold a hearing?
Hi, Senator. I do not believe that I did. I did review all of the motions that were submitted in support. I would also like to note, Senator Cruz, that...
So let me ask you, why didn't you hold a hearing?
Because I had all of the papers that I needed to review, but also
So is it typically your practice to hold a hearing on more difficult questions or closer questions?
Not necessarily, Senator. You have to understand that in our district, I have 1,156 cases on my docket.
How frequently do you hold hearings?
Ideally, I could hold them. It just depends. We're pretty busy. We have a lot of trials as well.
So, but the fact that you didn't hold a hearing suggests that you viewed this as a pretty straightforward question. Let me ask you something. There was some discussion with the chairman about an ICE monitoring. What are the differences between location monitoring by pretrial service and ICE?
So, Senator, my understanding was that the ICE location monitoring was actually more extensive, and if I recall correctly on this case, I think pretrial services, and as I said, I've issued over 1,000 orders, also recommended that it be removed.
So I find it quite remarkable that someone who assisted in hiding a murderer who killed a police officer, that you would, without even holding a hearing, say take off his ankle monitor, even though he was an obvious flight risk and an illegal alien. And there is a real difference, pretrial service monitoring. The defendant is allowed to leave his residence from 8 a.m. to 8 p.m., and the defendant is monitored daily In contrast, ICE has location monitoring in place to facilitate attendance at administrative immigration proceedings, not to ensure compliance with its orders in this criminal case. ICE doesn't directly monitor the defendant. Rather, a government contractor, BI Incorporate, monitors. How do you explain to the citizens that monitoring an individual who had already helped one person who'd murdered a police officer was not a priority, apparently, in your court?
I wouldn't describe it as not a priority, but Senator, as well, the fact that the ankle monitor was removed does not mean that pretrial services doesn't check in on him. He still has to report to pretrial services as is
Could he have
scheduled.
returned to Mexico?
I'm sorry.
Could he have returned to Mexico?
I doubt it because ICE had the other monitor on him.
Thank you.
Senator Welch?
Thank you. I want to give Judge D'Alba an opportunity to respond to any of the questions that you were asked about your cases and sentences.
Thank you, Senator Welch. Other than saying I do take an individualized approach, I do take my job very, very seriously, especially when it comes to sentencing. Those cases regarding child pornography are especially difficult as well. As I stated to Senator Blackburn, prior to becoming a federal district judge, I was a juvenile court judge, so I see firsthand the impact that these sorts of cases have on children. That being said, I am required, and I do take it seriously, to review 18 U.S. Code Section 3553A factors, as well as the Ninth Circuit precedent and the Supreme Court precedent on making these individualized assessment. It is not my job to rubber stamp what the government requests, what probation requests, or what the defense wants. I have to look at every case for what it's worth, and that's what I do in every single case that I impose a sentence.
Let me ask you another question. You did a lot of work prior to your service on the bench as a litigator, and how does that experience inform your work as a judge, both on the Superior Court and obviously on the federal court?
Thank you, Senator. I have always known I was very, very fortunate to work at a firm where they taught me, the managing partner at that firm, his father happened to be a judge on the Fresno Superior Court. And so for him, it was always very important to teach us as young attorneys the importance of being honest with the court in every single instance so that we can build up our credibility. And so as a young attorney, that's always been my practice. And I've also always gotten along well with opposing counsel. I've always, been able to work through very difficult cases, factually difficult cases, and yet I am able to get, through them well with working with others. That would serve me very well on an appellate bench, given that it's an three-panel situation. So I know that my former experience working in a law firm with partners, having to get their agreement on taking my, for example, contingency cases is going to help me also on the appellate bench.
Thank you very much. Judge Ramirez, I'm really happy about you receiving the support of Senators Cornyn and Cruz. That's a very powerful recommendation. Oh, you've had about three decades of legal experience as a litigator and on the bench. From your work as a magistrate in particular, which obviously is different responsibilities than what you would have on the federal court bench as a judge, can you elaborate on how that experience will inform your future service?
Over the past 21 years, I have managed approximately 2,900 cases between the consent cases and the pretrial management cases. I have issued almost 5,000 opinions, either memorandum opinions and orders, and findings, conclusions, and recommendations. And I've ruled on more than 16,500 motions. Part of the work that I've done is appellate in nature. For example, in the Social Security arena, litigants appeal adverse administrative decisions, and it is actually an appeal to the district court. Likewise, in the habeas arena, we review state court proceedings under a deferential standard. All of these experiences will inform my work on the Fifth Circuit Court of Appeals, should I be so fortunate to be confirmed.
Okay, thank you. I yield back.
Senator Ossoff.
Thank you, Mr. Chairman, and Judge Ramirez, Judge De Alba, congratulations on your nominations, and welcome and congratulations to your families and loved ones as well. Judge De Alba, Judge Ramirez, in that order, please. Will you pledge to faithfully apply the law with impartiality and without regard for your personal policy or political preferences?
Senator, I have done that and will continue to do that, yes.
I do, Senator. I believe my record shows that I have done that over the past 21 years.
Thank you both. And question for you both again, please, beginning with Judge Ramirez. Why, in your view, are First Amendment protections, including those of press, of speech, assembly, so vital in our society?
As the Supreme Court has recognized, those are important fundamental rights. They were so important to the framers of our Constitution that they were placed in the First Amendment.
Judge De Alba?
They are the bedrock of our democracy. We need freedom, for example, of the press, so we know what is going on. We need freedom of speech so that we can speak to those grievances that we feel that we have. We need to be able to petition our government. We need the right to assemble so that we can come together if there is a need to discuss any issues. So it is fundamentally important. And to echo what Judge Ramirez said, it's no, it didn't just happen that it's the First Amendment.
Thank you both. And final question, beginning with you, Judge De Alba, please. Sixth Amendment protections and the precedent established in Gideon v. Wainwright, establishing a right to counsel. Why is that so important in our judicial system, particularly for indigent defendants?
Senator, if we're going to take somebody's life and liberty away, we better make sure we got it right, that we have the right person, that they committed the crime that we are alleging that they committed, and oftentimes the individuals who come before the court may not know how to represent themselves. So it is extremely important that they have someone in their corner to help them navigate the criminal proceeding. It's also important, their right to a speedy trial, their right to a jury of their peers. And so I think it is an extremely important right that should be and continue to be protected.
Thank you, Judge De Alba. Judge Ramirez?
I have often stated to our public defenders and our defense bar when I've spoken to them how important the work they do is to our adversarial system of justice. Only by testing the government's case can justice truly be administered. I believed that as an assistant United States attorney. I believe that as a judge.
Thank you both. Congratulations again. Thank you, Mr. Chairman.
Thank you, Senator Ossoff, and I want to thank the two nominees for coming before us today. At least one of you has had that experience before. This becomes somewhat routine from this side of the table because of the hundreds of nominees who come through. And yet we need to remind ourselves today and every day that what we are doing here is literally a validation of that Constitution which we've all sworn to uphold and defend, to make certain that this branch of government, the judicial branch of government, brings to its leadership men and women who are qualified. Of course, this is one of the unusual things in our government that is a lifetime appointment. There are terms for senators and congressmen, but this is for the rest of your life if you choose. And we certainly hope when you are confirmed you will choose to do that. And those who witness it may wonder, well, why do you only spend 5 minutes per senator? Surely you can't take the measure of a person in that short period of time. You see many different approaches of the senators in terms of questioning. That is their own personal inclination. But I will tell you that a lot of work, as you know better than anyone, has gone into the preparation of your coming before this committee. Background checks in detail, disclosures from you in detail, reviewed over and over by some of the men and women who are sitting behind me. It's a long process that culminates in this actual public hearing. I want to thank you both again, but also your family and friends who joined you today. I'm sure it means a lot to have them in your corner cheering you on. So we may have some written questions coming your way, and if we do, I hope you'll respond to them as quickly as possible. I thank you again and congratulate you for this stage of the process. We hope to move on to the next stage with dispatch. And with that, the Senate Judiciary Committee stands adjourned.